Here in regards to that matter, sir.
Excuse me?
I'm here in regards to that matter.
Okay, you said I'm here. Who is I? Who are you?
Living man.
Well, if you're talking to me, I suppose you're living. I hope you're living, unless I'm assuming. There's nothing funny. Who are you?
My name's Roman, sir.
Roman?
Yes, sir.
Oh, well, are you an attorney?
Yes, sir.
Well, unless you're an attorney, you don't need to represent Mr. Daniel McDonald. You can have a seat. You said Roman,
Yes, sir.
and you're not an attorney?
Yes, sir.
What's your relationship to Mr. McDonald?
Depending.
Are you representing Mr. McDonald?
Yes.
But you're not a member of the Florida Bar?
Yes, sir.
Are you a member of any state bar?
Yes, sir.
Did you go to law school?
Yes, sir.
So how are you representing Mr. McDonald?
I would just like to ask some questions in regard to that matter, sir.
You can answer my questions. Your name is Roman McDonald?
Yes, sir.
And are you related to Daniel McDonald?
I just go by Roman, sir.
You just told me that. Are you related to Daniel McDonald?
Yes, that the name on your docket is in relation to me. Yes, sir.
Well, you stood up, so I'm assuming it's in relation to you, but you're not, are you Daniel McDonald?
Yes, sir.
Come on up, Mr. McDonald. That's nothing funny. We don't have time for these games. Come on up.
I just go by Roman, sir.
Well, all you had to do is say I'm Mr. McDonald. You didn't have to say I'm representing him. I'm related to him. All you had to do is say I'm Mr. McDonald and come
I
forward.
apologize for the confusion, sir.
Okay. Has the state filed an information in this case?
No one calls me Daniel.
One moment. Has the state filed an information in this case?
Not this time, right?
All right, Mr. McDonald, we will see you next month for an arraignment, November 12th at 9:30.
Sir, I haven't entered any type of plea out of
I know the state hasn't filed an information. It's not time for you to enter a plea. If the state decides to file an information, you can enter a plea at that time.
Can I motion for dismissal right now based on procedural grounds?
There's nothing to dismiss. The state hasn't filed an information. What are you dismissing?
That I put in an affidavit and a demurrer, a motion to dismiss, and it hasn't been responded to. I think the state attorney has 15 days to respond to that motion, and they have not.
A motion to dismiss what?
The cases, the matter.
The state hasn't filed an information. There's nothing to dismiss. There's nothing to respond to. If the state decides to file an information, you can renew your motion to dismiss. If you're going to represent yourself, Mr. McDonald, and if so, I'll ask you a few questions. But right now, the state hasn't filed an information, so we'll come back November 12th at 9:30, okay?
Sir, I got two more questions if you don't mind.
Yes, sir.
Is there a verified claim against me?
A verified claim?
Yes.
I'm assuming you're talking about an information. The state hasn't filed an information. That's under oath and is verified.
Are there any orders? Can I be released to orders of the court?
Were you arrested?
Yes,
You're not in jail?
correct.
You were released on orders of the court already.
Is there anything additional, orders of the court, or just waiting on the prosecutor to file additional information?
Right, not an
Before anything
additional
else
information, waiting on the prosecutor to decide whether or not they're going to file formal charges in the form of an information. If they do, you can enter your plea. And if you want to file a motion to dismiss, we'll set it for hearing.
Is there any reason why they hadn't filed any already?
That's none of my concern. They have a statutory period of time to file an information. And if that time comes or goes, we'll address it. But right now, they haven't filed an information. If you hire an attorney, your attorney can reach out to Mr. Patterson. If you want to represent yourself, I'll ask you a few questions next month and you can speak with Mr. Patterson about it. More likely than not, for self-represented litigants, attorneys, prosecutors only speak to them on the record. So we'll come back next month at 9:30, okay?
Sir, my only problem is I live 6 hours away.
Oh, all right. You can always hire an attorney and they can file a notice of appearance and written plea of not guilty for you. If you want to seek the services of the public defender's office, you can fill out an application. The clerk will determine whether or not you're indigent. And if you are, I'll appoint the law office of Henry Mark Sims to represent you. And Mr. Hill knows exactly what he's doing. He can contact my office and file a waiver of presence or ask that you appear by Zoom. But right now, we'll come back November 12th at 9:30.
I would, if there's any way possible, I'd like to handle these matters today.
Handle what matter?
Any matters. in regard to that name. And I know you have business to attend to, so I
Yes,
don't
sir.
wanna hold you up, but
No, you're not holding me up. We are attending
it's
to,
not easy to take 2 days off work to be here and then nothing happened. You know,
well, I just told you what you can do. So we'll see you November 12th at 9:30.
like
You can sign this notice.
Hey everybody, welcome to American Courts. That was an interesting one. I wanted to throw there at the beginning. He tried to be sovereign citizen, but Judge Collier not going to do with that. Judge Collier does a good job of shutting people up like that. I want to thank all the moderators. We got a pile of them, so I'm not even going to try to go through the names of everyone. But thank you everybody for helping keep it clean on here. At 9 o'clock, Court Addict with ATX Alley coming up over at American Courts 2. It'll send you over there. I think I may have got some of those minor issues figured out over there. Y'all keep me up and let me know if you see any improvement over there. November 6th, I get to hit up YouTube to see if they want to pay me. And so that's going to be a good day. That'll make a difference on showing more videos on the channel or not. I don't want to add too many more videos because everything you add for them is a way for them to get onto you. So I try to keep it, trying to do more lives and do less regular videos over there. So we're going to jump over to let's jump over to another. I will start with the Judge Simpson one, and then we'll get to another Judge Collier. So here we go with Judge Simpson one.
Court calls case People versus Brandon Hampton.
Public Defender Fellow Nicholas Bukovich on behalf of Mr. Hampton.
Your name, sir?
Brett Hampton.
Thank you. You're requesting an adjournment?
Yes, I am requesting an adjournment to obtain media to be able to view it with my client. I believe I accidentally sent it to a request to the law prosecutor at this time. So
Can I decline that and have the people actually prove that I'm guilty of anything?
Pardon, sir? What?
I'd like to decline that and have the people
No.
prove that I'm guilty of something. 'Cause I'm not-
Decline what?
Mr. Hampton.
What are you declining?
I want the people to have to do what they have to do today. Their premonition trial.
Well, you
No,
want me to try
we
to,
can set that out for that. However, we want
Because we don't need to do anything today. They need to prove that I'm guilty of something.
Mr.
Oh.
Hampton, Mr. Hampton, this is not.
Mr. Hampton,
No,
I understand the burden. What your counsel's doing is he's making sure to look at everything that the people would be looking at.
They're going to be giving me the videos they have so I can see what they have.
Yeah, and I want to know what they have now. Let's see it.
Well, that won't happen today.
It will not happen. We can set up a preliminary exam another day once we have the video and know what they have.
November 7th, 2024, 9 a.m. Bond continued. Thank you. You know what? I don't think you want to do that, sir. You hear me?
I apologize, Your Honor.
He better take himself out of here because otherwise he's going. You're gonna go. Keep it up.
I apologize, Your Honor.
Why? Did you start it? Okay, let's see who's next.
What do you want to say? I'm Bernstein with him on behalf of Mr. Gregory.
Good morning. Yeah,
All right.
And I know there's a bond violation that we probably have to address first before the next stage, if the court would like to do that.
Yes, go ahead.
So it's for not making it to community corrections as referred. Your Honor, Mr. Gregory's had a very rough time once he got out of jail. He's an epileptic and he didn't have his seizure medication while in there, and his brain's been a little fried. He enlisted his mom's help when he got out after community corrections gave him a call, and she called a couple of times but wasn't able to get through. So it's just been very.
Who called?
His mom called.
Called where? Community corrections?
Yes, after they called
When
Mr.
did
Gregory.
that take place?
The day that he told her. And I talked to her this morning, last night. She said she left several messages.
When? Because it's not even reported on here. Ms. Mahal.
The day that,
Go ahead.
the day that he spoke with Community Corrections, Your Honor, that's what, she told me. She called several times and tried to make contact.
That's not what this at all says.
Well, she left voicemails, Your Honor. I don't expect them to write down voicemails, but she was trying to help him. Hold on. When he got out of jail, he did not have his seizure medications. It was still at the jail. He's been having a very difficult time. He went to the hospital for almost a day because he was seizing. It's just been very difficult for him to get his affairs back on his feet after release, Your Honor. He tried to have his mom's help. He didn't quite get there. They went to Community Corrections this morning to try to rectify it. When I informed them about it last night, they said that he needed a new referral. I talked to him about what this all entails. He has absolutely no problems going to Community Corrections.
Go ahead. I'm listening to you, but I'm also looking at what's stated here. He said he needed to talk to his mother regarding the appointment, and we haven't heard from him.
Yes, sir. He did not go back to Community Corrections after that phone call. He tried to have his.
Why not?
I didn't understand where it was at or how to do it. I'm not gonna lie.
He scheduled an appointment. He telephoned them and scheduled his intake for October 17th.
Yes.
He failed to appear for that appointment. Where was he?
He was at home, Your Honor, with his mom. Like I said, he was having a very difficult time. He had spent time in the hospital after getting out of jail. He didn't have his medications because he can't re-up them after he leaves. And so he's been having seizures on and off. His brain's been fried. I know people with epilepsy, it's a thing where your brain gets fried to where you can't think straight. That's just the condition he's been in for the last.
They then called him and he stated he was suing as he was not given medication while jailed and could have had a seizure.
Mhm.
Then he stated, according to this, he needed to talk to his mother regarding the appointment.
Right, Your Honor. And that's my
And then we haven't heard from him.
And he tells me, and I've spoken with his mom, that he told his mom that she was trying to help him through the issue. She
What
called
do you
Community
want?
Corrections.
There, is that his mother?
Yes, Your Honor.
The one waving at me?
I do believe so.
What is your name? What do you want to tell me?
Just on the lead time, really, it wasn't, his father called and scheduled, whatever. I didn't know anything about him having to report to me, even though I was finding him out. Once I did hear from him stating that he was supposed to be with community corrections, I called several times and left messages just to come back to see exactly what was going on, because I didn't know. So with the lawyer yesterday about 3 p.m., he told me about the violation and what needed to go on. I let him know that I would take action of community correction to get scheduled and get what needs to happen. He didn't tell me that we needed a new referral. When we went this morning, they didn't come.
He should have gone over there the first time.
That's correct.
I don't even hear a reason why he did.
We just didn't know what was
I
going
didn't
on.
know what to do.
You called them.
That wasn't me. I don't know nobody. I don't know what to do.
And as far as the seizure medication, we still weren't able to get that today. So he still does not.
The report I have indicated he called over and scheduled his intake for October 17th.
That was,
I didn't call nobody.
that was his father.
And your father didn't let you know that it was scheduled for that day?
Nobody did, sir. Nobody. I didn't call no one.
What are we doing on this case? I don't believe any of this, but go ahead.
Well, what I do, I guess, depends on what, I was begging for a second chance for him to get to Community Corrections. He can go there right now. I have good contact with him.
What are we doing with the case is my question.
I have a green form to ask for an adjournment, Your Honor.
Probable cause conference, October 31st, 2024, 9 a.m. At this time, I'll let his bond continue. I'm signing a referral right now. You need to go over, once you leave here, you need to get over to community corrections and do the intake. Am I clear?
Okay.
Thank you. Court calls the case of People versus Ahmet. Is it Enright?
Yeah.
We're ready in this matter, Your Honor. Warren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Aaron Wright. Mr. Aaron Wright, please state your name for the record.
Good morning. I just wish to mention for the record that earlier this month, I mailed 2 letters, one to the prosecution and one to the attention of the judge. And my name is Amit Ehrenreich.
Your Honor, as the court knows, this matter has been out for competency. We have not yet received a report. I've spoken with the prosecution. I don't believe they have one.
So people do not have a report either?
I don't have a report either. So I will adjourn the competency hearing out. I usually put it out 30 days. Put it out to, what's mine? It's at 26.
Yes, and I
November 26, 2024, 9 a.m. Bond will continue. It should be noted that there were indeed letters sent to the court. They're in the file if you did not get a copy. They were written on napkins. So we did not 2-hole punch them. They're in the envelope here.
I was not on the Christmas card mailing list. I did not get a copy. So I will be happy.
We'll be more than happy to share the napkin with you. Don't wipe your mouth with it, please. Thank you.
Thank you.
You're welcome.
I like Judge Simpson right there at the end. He still cracks a smile. You can tell he was aggravated. He had a busy day that day, and everybody was being an idiot. So, hey, everybody that's showing up since then. Gina, that fella there at the end, probably about a month ago when he came out, he went to hand the prosecutor's office a letter, and it seemed very aggressive, and it got the attention of security, and they put him up for a competency exam, and he's not all right upstairs, and so they're yep, Nan, he's the guy who approached the DA and scared the hell out of her with what he did. She ended up having to leave the courtroom. And so he's a mess, and he's got to get his stuff figured out. We're going to jump to another Judge Collier one. We got another one, and then we got a little bit longer Judge Simpson one I want to try to get through. That way we can go see Allie. So let's jump to Judge Collier.
Good afternoon, Your Honor.
Good afternoon.
We got Henry Davis, 24 CF 42 and 24 CF 59.
Okay.
Your Honor, at the conclusion of my last contact with Mr. Davis, of course, we're here on the trial management, but at the conclusion of my last conversation with Mr. Davis, he announced to me and told me that he would like to represent himself. So I think maybe the first thing we should do is take care of that matter and see where we go from there.
All right, Mr. Davis.
I told him I don't want him on my case. It's exactly what I told him. Same thing I told you last time we were in court. I mentioned to him about the felony battery that I caught here in the jail. The charges were filed 90 days after the 40 days. Well, 90 days within the 40 days, he was filed 90 days. They didn't file within the time. He was telling me, they have 5 years until they can file charges. And I never read nothing about that, but that's what he was going on about. He didn't have no depositions. He didn't even read up on the case. He didn't know how many witnesses was in the case, none of that. He doesn't know anything about my case, but he was willing to go to trial on my case before he even knew anything about my case. I don't know how I was supposed to go forward with this man. I even told him to file something. He told me that's a waste of the court time for him to file it, so he's not going to, which I presented to him and said, well, you're supposed to be working for me. You're supposed to look out for my best interests. So
what did you want Mr. Williams to file?
On the felony battery that I caught in here, it was supposed to be 40 days until they filed, as everybody knows, but it was always a 90 days. that charge held me without bond. And then it says it's supposed to be released, but I know I can't get released because I have other charges, but still, it should have released me in the system so I would be able to bond out, go get my lawyer and get everything right that I needed to. I still was not. I tried to explain that to him. It didn't register or whatever. And he said, oh, we can't, we don't have a communication, we need better communication. Which, as I told him, if I'm explaining something to you, you're trying to tell me, no, that's not what it is. Obviously, there's no communication that needs to be fixed. You were just trying to tell me what the book says is not true. So I would like to remove him off my case.
Mr. Williams?
I think what he's saying, Your Honor, with regard to the 24 CF 59 case, that's the detention, the battery in the detention facility. He feels that since the state did not file the information in that case within 30 days, that charge has to be dismissed. I explained to him that the statute of limitations on a third-degree felony in Florida was 3 years. So the state had 3 years to file that charge, that it wasn't barred from filing that charge by the statute of limitations. That the procedural rule he was talking about is if you're in jail, if you're put in jail and a charge is not brought in a certain period of time, if the information is not filed, then they can't hold you in jail any longer. But it doesn't mean that they can't eventually charge you in the case. And in his situation, he was already in jail on the 24 CF 42 case, so that it had no practical effect in this matter. So that was what that conversation was about, and it lasted for quite a bit of time. And then eventually, I told him I was not going to file a motion to dismiss based upon that because there was no legal basis to do it. And he had his opinions about the legal issues involved, and I explained to him that was my decision, and that what we really needed to do was to talk about the case, that we had a trial coming up next week, and that he needed to assist me in preparing a defense for him. He just refused to do that. So.
Or anything else?
When I first met this man, I tried to speak with him on that first case. He told me, and I'm in that verbatim, none of that matters. What I'm saying is, all of that stuff you're saying, we need to just, who you got to blame for? You can't blame nobody else, it's just y'all two. Not knowing I even had other witnesses so-called on the case. That's what he said, verbatim. So I'm not finished. Listen, we both grown. I ain't got time, I ain't got to really lie and play around. I told this man, listen, he's talking about 30 days. It says 40. I never said nothing about no 30 days, none of that. I said 40 days, as I just sat here and told you. I told him, I said, listen, this case that we're talking about is the case in here. If they would have released me on that case in the system, I would have been eligible to bond out. They did not do as the law says do. Or that doesn't matter, you were charged on another case. Well, that other case does not have nothing to do with this case. We're talking about this case, not that case. You're trying to, you keep trying to run these cases in together. You're constantly doing that. You're trying to get me to, you're not a trial lawyer. You don't want me to go to trial. You want to take a plea. You've been shooting for this plea since I met you. It's the same thing you keep shooting for. You keep shooting for a plea, I told you I'm not pleading. I'm going to trial. I've told you this. You keep constantly, well, it don't look too good for you. Well, you're my lawyer. You ain't supposed to be telling me nothing like that. You're supposed to be like, okay, what can we do? What is the defense? Where can we go? You're not asking me none of that. You're just trying to, okay, just go ahead and sign and get it over with. You're constantly just making up stuff and just trying to go along, trying to make it sound so sweet on your side. I'm not going to lie to you. I'm not going to lie on you. I have no reason to do that. You can ask these officers. If I did something, I'm going to tell you I did it. I have no reason to lie. So as I'm sitting here telling him, I do not want you on my case. You are very incompetent. You're not fit to work my case. I don't feel like you are, because you have not wanted to ask me, hey, let's talk about what happened in the beginning. Hey, let's talk about the beginning. How did this start? How did everything start? You not once asked me that. Not once have we even gotten close to that. Every time it's, oh, no, that's not right. Then he tell me about the case. Well, I watched the video. I'm trying to, oh, you can't tell me nothing. Come on, I watched the video, man. You can't tell me nothing. Come on, just. But now in here, you're just, you're trying to all sweeten it up, and I'm not with that. I do not want this man on my case. I'd rather not have him on my case. He's not fit to work my case. And that's just the end of that.
All right, Mr. Williams is a trial lawyer. He's been a trial lawyer for some time. After listening to you, Mr. Williams, I'm gonna find there's no reasonable cause to believe that Mr. Williams is rendering ineffective assistance to counsel. If you want to discharge Mr. Williams, I need to advise you that the court will not appoint another attorney to represent you. So if you still want to discharge Mr. Williams, I'm going to take that as a exercise of your right to represent yourself. And if you want to do that, I'm going to need you to place you under oath and ask you a few questions. Is that what you want to do? Is that what you want to do? Okay. Raise your right hand for me. Could you tell me your age and your highest level of education?
27 years old, and I got my GED.
And do you have any familiarity with the court system?
Yep.
And what's that familiarity?
Well, I have a book that I look up, but I know my law. I know I'm supposed to be charged with domestic violence too, along the guidelines of domestic violence. We ain't gonna speak on that here today because you said that that's for a jury to decide.
You just need to answer my questions. Mr. Davis, do you understand the advantages of having an attorney represent you?
Like this time?
Do you understand the advantages of having an attorney represent you, Mr. Davis?
No.
Do you understand that an attorney is trained in the rules of evidence and courtroom procedure? Do you understand that?
Yes, so.
Is that a yes?
Yes, so, sir.
Do you understand that being trained in the rules of evidence and courtroom procedure, attorney can give you advice on how to proceed with your case?
Yeah. Can I ask you a question?
You can answer my question.
With that advice, can he tell me that he's not going to file?
Mr. Davis, you can answer my questions.
Okay.
You understand? Do you understand that?
Uh-huh.
You understand that if you want to represent yourself, what I'll do is I'll hold you to the same standard as an attorney. Do you understand that?
Mm-hmm.
Is that a yes?
Yes.
Do you understand that the lawyer can call witnesses for you
Yes.
and can compel the attendance of witnesses?
Yes.
You understand that the attorney will be able to question jurors during voir dire?
Mm-hmm.
You understand that?
Yes.
And
You're shaking the head. You just keep because you're trying to.
You're shaking your head, but you're not answering me audibly.
Do the same thing.
Listen to me. That we're recording this, so I need to ensure that you are competent to represent yourself, Mr. Williams. You understand that?
Yeah.
You understand that?
Yeah.
The advantages of having an attorney.
Mm-hmm.
Understanding that you still wish to waive your right to an attorney. You want to represent yourself. You understand that if you represent yourself, I'm going to hold you to the same standard as an attorney.
You just asked me that.
Do you understand that?
You just asked me the same question.
Do you understand that?
Because you just asked me that same question.
If you don't want to answer my question, I'll find that you're not competent to represent yourself. Mr. Williams is still on your case. So just answer.
Because I told you.
Answer my question.
Is if I don't want him as my lawyer.
Would you answer my question, Mr. Davis?
All right, I just answered that question. You're going to keep asking me the same question over and over again.
You understand you would not get any special treatment from the court? Do you understand that? Let me ask you again. Do you understand if you represent yourself, you are not getting any special treatment from the court?
I'm not getting special treatment now. Why would I get it then?
I'll ask you one more time. Do you understand if you represent yourself, you are not receiving any special treatment from the court? Is that a yes? You don't want to answer that question, Mr. Davis? Do you understand that you have trial Monday, jury selection?
I didn't know I had trial Monday.
Do you understand that you would not be entitled to any continuance simply because you want to represent yourself? If you don't want to answer that question, do you understand if you are convicted on appeal, you can't raise the issue that you did not have an attorney to represent you? Or that counsel was ineffective since you'll be representing yourself. You understand that?
Why do you feel like he's competent to represent him? When I just sat here and told you everything. Everything outside what I said, you still said he's competent to represent.
Do you understand that if you are disruptive in the courtroom, I can terminate your right to represent yourself and appoint counsel? You understand that?
I appoint him.
Do you understand, Mr. Davis, that if you disrupt the courtroom, I can terminate your right to self-representation and I can appoint counsel to represent you? Do you understand that? If you don't want to answer my questions, I just find you not competent to represent yourself, Mr. Davis.
Oh, you don't gotta worry about it.
All right, I'm going to find you not competent to represent yourself, Mr. Williams. You'll stay on the case.
No, you won't.
So we
I know my
have
right.
a jury selection on
It isn't.
Monday.
Get off my seat.
A few things, Your Honor. if I could.
Mr. Davis just voluntarily left the courtroom.
I know at our last hearing, there were some issues raised about the score sheet, and I just wanted to update you on that.
Yes, sir.
If you recall, Mr. Davis had claimed that there were things that are on the score sheet that he hadn't done. And I told the court that we would look into that, and I'd get with the state attorney. We have done that, and we have a corrected score sheet now, which basically changed his lowest permissible sentence from 76.950 months to 56.10 months. So that's a 20-month reduction in the LPS. And I haven't had a chance to talk to Mr. Patterson, but previously the state's offer had been that LPS. I assume it would probably still be the LPS, which would be 56.10 months.
Yes, that's correct.
If you're not prepared to answer that, I didn't mean to catch you off guard, Mr. Patterson. That's fine. Okay. Well, I just need to know that
Yes,
so
sir.
that I can at least try to communicate. Well, I don't know that it really is in play anymore since I guess today's the cutoff date for that, isn't it?
Or we can bring him back tomorrow if Mr. Davis is interested in accepting the plea,
Okay.
or we can talk to him about it.
Well, I can go see if he'll talk to me.
Oh, we have time this afternoon if you want
Okay, I'll
to
go
see.
see it and then I'll
Okay.
come back. Okay. Your
All
Honor.
right, that's what we'll do.
The other thing I wanted to, I did want to correct just for the record that, he said I didn't have any idea what the case, what was going on. He mentioned depositions. I have reviewed all the discovery in the case. Mr. Hill previously had represented Mr. Davis and conducted depositions. I have obtained all of those, the audio recordings of all of those depositions. I've listened to every one of them. I just wanted that on the
Yes,
record.
sir.
All right, Your Honor, if it's okay with you, is Mr. Davis still back there?
Yeah, we can bring him back, talk to him and see if he want to take the plea. If not, just come back out and let us know and
We'll
we'll,
do that.
all right.
And Your Honor, with Mr. Williams here, I know I filed a number of motions related to the trials previously. This was not one of the cases I filed it in because I was unable to get in touch with Mr. Williams to find out his position on such a motion. I have, as the court's aware, these cases are all new to me. I've sent subpoenas on this case in an effort to try to be prepared for trial. As the court can see from the file, this is a felony battery based on the harm and the injuries done to the victim. A number of the doctors in this case are unavailable. One is actually out of the country. And as a result of that, I feel that I am not going to be prepared next week to present the case because the doctors who were to testify about the injuries received by the victim are unavailable. And as I said, one is actually out of the country.
All right, Mr. Williams?
Well, I wasn't aware of that, Your Honor, but under those circumstances, and I'm sure the state's made reasonable efforts and diligent efforts, so I wouldn't feel right in opposing that request for a continuance.
All right, we'll move this off the trial docket. We'll bring him back on. He refused to return. All right, so we'll just bring Mr. Davis back on November 13th. That'll give you some time to
That'll
see
give me a chance.
with the corrected score sheet whether or not he wants to entertain the plea.
And what was that date, Your Honor?
November 13th at 10:30.
November 13th. I'm sorry. Oh, okay.
Thank you, Your Honor.
At 1:30, Your Honor?
10:30.
10:30. Thank you. Sorry about that. And that's the only case I have, Your Honor.
Well, that was an odd one. I've never seen an inmate be able to just leave the room like that. So that was neat to see. Judge Collier, just to give you a little bit of history on him, he's I think he's in his early 30s or maybe mid 30s at the most. His mom had him when she was 17. He has an older brother that she had when he was 16 or when she was 16. So he's come from some pretty humble beginnings. He was a prosecutor down in Panama City and got appointed by the governor for a judge, and he's done a damn good job. He's caused a little controversy because he's so direct and so blunt, but he's a really good guy. I really support him. I haven't seen anything he's done that's made me question the way he's thinking. So But it was odd to be able to see the inmate just be able to walk out like that. I kind of feel like in other courts that would ended up with a scene, maybe ended up with 2 or 3 shorts out of that one, but not with him. He knew that he wasn't going to let him play him. It's time to pay the bills. This channel is sponsored by a company called Aura. Internet security. They keep track of your cards. They keep track of your information. I get an email about 2 or 3 times a month asking, did I use my information here? Did I use my information there? Because it's showing up on databases. I simply answer yes or no, and then it goes away. I had a larger purchase a little while back, and it sent me an alert to tell me about it. And so it was handy. It's not going to harass you. It's not going to bother you. It's not going to just constantly blow up your phone. So go check it out. Use that link up top there, that aura.com/American Courts, and you can get a 14-day free trial. It's worth it. It's worth it to check it out and try and see how it does, and it does help the show. So make sure you check it out. I'm going to jump over to a Judge Simpson one. This one's about 40 minutes. It's a good one. It's interesting. It's exciting during the whole thing. It just may push us past the 9 o'clock hour, but it's all right. Allie enjoy the break. So we're going to jump over to that.
Court does call the case of People versus Jillian Carey.
Good afternoon, Your Honor.
All right. We're here on the motion, your motion for discovery, to compel discovery.
Yes, Your Honor. Should I begin?
Go ahead.
Yes, Your Honor. I moved for discovery of potentially exculpatory material under MCR 6.201. I made that request in July. The prosecution had 21 days to comply and did not provide anything or any response until very recently. Last night I received his response to my motion. I filed a reply today, Your Honor. I'm not sure if you had a chance to.
I read everything, counsel, so.
I know I could. So if you read everything, then you know what I'm asking for. And I'm asking for discovery of communications between the alleged victim, who's a fellow by the name of Will Hathaway, outgoing Scioto Township supervisor, and communications between he and members of the prosecution team, which include officer.
How do I know these exist?
Sorry, how do you know? Well, I believe they exist. I know for a fact that there are emails after the discovery was produced to me between the key detective in this name is Detective Harvis. He's a quote unquote computer expert in the case. And
well, he's not quote unquote a computer expert. He's extremely skilled in what he does.
I'm sorry, I didn't mean
go ahead.
But I don't know what his title is. I was just saying computer expert. But he has been having communications with Will Hathaway, who's the complaining victim, and also with members of the IT department of Scioto Township. There have been emails. There's written communications between witnesses. And
how do you know that?
Because I learned that from my client because Mr. Hathaway was talking about emailing with this gentleman. I believe they exist, and Detective Parvis also came to the township and met with Mr. Hathaway, trying to follow up on the information that we provided to the prosecutor, showing why this case is completely a non-case, that there was no crime that occurred in this case, not even a crime, let alone my client committing a crime. There wasn't a crime. An old email and an old meeting request were sent when my client clicked.
I've read that, counsel. I'm just trying to figure out how I know these things exist.
You don't, Your Honor. You don't know until you look. And when I asked the prosecutor for this information, he said, on information and belief, I don't think they exist. That is not the proper response from the prosecutor, Your Honor, and you know that. The prosecutor's response should be, I checked with the sheriff's department, or I looked at these materials, or they don't exist. All I got was,
well, what information and belief? Why you may not like the response, but the response is his information would have had to come from somewhere. So you're talking what words he was using as opposed to anything else.
No, I don't think so. Respectfully.
Well, I do.
Okay, well, do you understand what I'm asking for?
Not really, because I don't know what documents you're saying exist that the prosecutor hasn't turned over.
Okay, I'm saying that there are emails for sure between Detective Parvis and Will Hathaway. He's a complaining victim, and I would ask for those emails to start. But I would ask for any written communications between any witnesses and the sheriff's department and the prosecutor's office.
Okay, so the only way you know that there are emails between Mr. Hathaway and Detective Parvis are because Mr. Hathaway said so?
I have a moment. I can tell you exactly. Can you give me 1 second?
Sure.
So, Your Honor, the way we know that they exist is because Will Hathaway forwarded those emails that he was having with the detective to another member of Scioto Township, another employee. That's how I know.
So where's that employee?
You asked me for testimony from a witness?
I asked you a question.
Where is
the employee that says they got the emails?
Well, they're not at work now. It's past 4 o'clock and we needed to have them here.
So this employee received, I'm presuming, on their personal email or on the Scioto Township email?
Scioto Township, Your Honor.
So my question becomes, why would your client, if they exist, not have access to those through their IT department?
Anything to me.
My client has not been able to get access to that. And I don't think she's requested access.
Well, counsel, do you have have you tried to get them?
Have I tried to get them? Me?
Yeah.
I've done a FOIA for communications at the township, but this is stuff that happened more recently when I did the FOIA. And it's, Your Honor, with all due respect, this is exactly what the prosecutor should be doing, is finding out, are there communications between my witnesses and my police officers that are.
No, with all due respect, what you will do is you will answer my question.
I'll answer your
question. You attempted to try to get them?
No. I mean, I did by filing this motion. How else am I going to get discovery, Your Honor? I guess I'm confused by your question.
Shouldn't be confused by my question. Look, the prosecutor is not required to do what is really part of defense's job. Certainly, they must supply evidence that they have and comply with any reasonable requests. But you come here to me today, and I don't know that these things that you're requesting, whether they exist or not. And the only way that you know that they exist is because somebody has said that these were sent to somebody at Scioto Township, and that it's between Detective Parvis, presumably, and Scioto Township. So my question is, on that end, why don't, if they exist, when did this happen? You're saying it's recent, but when?
I can get you a date. Within the last 2 weeks. But it's not just that, Judge.
If I may.
I think I'm still arguing.
No, I'm just trying to clear up the point here.
No. We don't do it that way here.
Thank you.
Just for a bit of context, Your Honor, if I may. Mr. Boloda provided me with some information from some computer person Dave retained. And it had to do with a meeting invite that went out around the same time that this email went out. That information was emailed to me, and I don't know, because I'm not a computer expert, what it is that this information entails. I forwarded that information to Detective Parvis, and I've spoken with Detective Parvez. He's attempting to, I believe the term is the header information that is retained on the servers at Silo Township. He's basically trying to vet that information, Your Honor. And so that has happened in the last few weeks, and perhaps in attempting to vet that information, Detective Parvez has been communicating with Silo Township. I have no specific knowledge of that. I haven't been provided anything, but it wouldn't shock me that Detective Parvez is following up because I asked him to follow up. He told me that at some point he's going to provide a report to me. I don't have any sort of report, and I don't have any update for the court. I'm only saying that in as much as I am aware that Detective Parvez has been communicating with the IT department of Silo Township over the last couple of weeks in response to information provided to me.
Okay, well, that's a big piece that's left out. So you provided something to the prosecutor's office.
Yeah.
That your expert provided to you.
Yes.
And then from that, the prosecutor's office then sends that information to try to figure it out. So how do I get to there? And so that hasn't been completed yet.
I've not had an update or any reports. My understanding is the IT individual from Silo Township, the primary person is out on some sort of leave. And the other information was that obviously with an election forthcoming, the current IT person has a lot going on. So there's a delay, I think, in getting that raw data to Detective Parvez so that he can, validate whether this is or is not true based on the defense expert.
So, I mean, is there anything in that that's not true?
No. And
so why am I here? If you gave them information and they're trying to unlock that information that you've given them, why am I here on a motion to compel that information where it's not been done yet?
Because that's not what I'm not asking for a follow-up report. I'm asking for communications, Your Honor, and not just with Detective Parvez and the IT person, but most importantly between Will Hathaway and members of
yeah, but doesn't that come from isn't that the subject matter of the meeting invite, or am I reading that wrong?
What is the subject? The meeting invite was for a meeting that happened 11 months or longer before. So it was an old meeting. That's why I say that this case was just essentially an IT issue. It had nothing to do with any individual action, anything. And that's why this case is started in this courtroom before you on this matter, because there is no evidence. And that's why I wanted to spend some time talking about the case to show you that the principal witness is Will Hathaway. He is a political rival of my client. My client was running for the position that he now holds for the time being, supervisor of Scioto Township. And he is a long time political rival. So he's the one pushing this prosecution, Your Honor. He's the victim. He went to the sheriff and he's pushing this. So all of his communications with the prosecutor's office and with the sheriff, I believe I'm entitled to. And at the very least, I'm entitled to the court to make an in-camera determination as to whether there's anything exculpatory if they exist.
If they exist.
I know. This whole thing could be solved if the prosecutor had said in his response, I asked, and there aren't any. I asked the sheriff, and there aren't any emails. There aren't any texts. That's all he has to do, but he didn't say that. He said, on information and belief, I don't know about any. And that's just not enough. That's not enough.
So you wanting to use specific words?
Well, I mean, the Supreme Court said that he has a duty to investigate material within the possession of the police. And he's telling me that he doesn't think there is any, but he doesn't say that he even checked.
Okay, so let's presume this, counsel. You make the request. Mr. Childers goes to the police department. Police department says we don't have any. He then has to respond to you. He doesn't know that because he can't say they absolutely don't. He can only tell you what he's been told. So if that's all that he can say, he would have to say on information and belief based upon, which is really going to be based upon conversations he's having. I don't have anything.
Understood. And I've been on that side, and all I would say is, look, I asked, and they don't have it. Okay, and maybe he did ask. I'd love to hear him say that he asked. But what I've heard from him, and I met with the prosecutor, Your Honor, is I heard from him that Will Hathaway made a contradictory statement to him, telling the prosecutor that he himself did not write the email that was sent, the untimely email. He had said to other people that he did write it.
I can't get into evidence on the case. You're asking me, I mean, you keep throwing this stuff out there. I don't know if that's the evidence or it's not the evidence. I'm here on your motion, which is quite frankly improper in the way that you drafted this motion.
How so?
But because you lay out all of these things that, and quite frankly, counsel, made certain accusations against people in some conspiratorial sense that turned out not to be true. For example, you specifically stated that Patricia Reiser authorized the complaint. I went to the complaint. I looked at the complaint. She did not. And then that was before I got the response from the people, because I didn't know for sure.
I didn't say that. I said that she worked there and that was her job, and that's factually accurate. And
then you misled the court, because you made it seem, as the one's reading it, as though she's the one that's authorizing it. Don't tell me, counsel, what my impression of it was. Okay. And I think you intentionally tried to mislead me. I'm going to let you know that.
I did not.
Because that didn't happen.
That's good. I'm glad it didn't. It shouldn't happen. It shouldn't happen, but it also shouldn't happen.
You know what? You better sit down. Because you're going to learn real quick how to address this court. I don't play that way. I'm going to take a recess. You check yourself, and then I'll come back. Court's in recess. Counsel, you've indicated emails between Hathaway and Parvis. What else are you looking for?
Thank you, Your Honor. And let me just apologize to the court. I know you took a recess, and I want to say I'm sorry. I did not mean to disrespect the court in any way. I apologize if my arguments came across that way. I would say that probably due to my extreme belief that my client is absolutely innocent. I apologize for my zealousness, making me feel that I was being disrespectful. I apologize. Other things besides that, Your Honor, communications between Will Hathaway himself and members of the prosecution team, including Parvis and Deputy Phillips, who's the officer in charge of the case. So that's what I'm asking for. Communications. And I don't need to say anything more. I'll rely on my brief.
Well, no, I do have a question. How do I know these exist?
You don't. You don't. I only know what I've heard and what I've reported to the court. And what I was asking is for the prosecutor just to check. And maybe I misread his response. Maybe he was saying information belief means he checked. I just want to know if he looked and if there's nothing, then
Did you ask?
I asked for him and he said he wouldn't provide them. So they weren't discoverable during
Mr. Childers?
Yeah, and the problem, this is now like the third time in this hearing, as well as multiple instances in the pleadings. The defense is misrepresenting statements that I've made to the point where I don't feel comfortable speaking with the attorney absent being on the record or in writing. We've had phone conversations and somehow the subject of those phone conversations shows up in the pleadings, inconsistent with what was actually said. There was a statement in the pleadings that the fact that the defendant passes private polygraph, I should act upon it, even though I specifically told the defense attorney that the only way we would do anything on the case is if she passed the police polygraph, because as this court well knows, that's standard procedure. That offer still stands if Ms. Carey wants to avail herself to a police polygraph. Not only would I welcome that, I think that a result on that could be highly dispositive in a case like this. It's my understanding that she's not willing to do that. That's her right. That's fine. As far as my communication with respect to emails, The statement that I was responding to that I would not turn over would be internal emails in our office among the attorneys, because clearly that's work product and that would not be turned over. But in fact, in that conversation, what I told defense counsel was, candidly, there are no emails. I've never emailed with Mr. Hathaway. If I had, it wouldn't necessarily be discoverable. It could easily be work product, but those emails don't exist. I've never emailed with him. I did communicate with Chris Reiser in our office. Obviously, I wouldn't communicate with John Reiser, and to insinuate others is frankly, when I read the pleading, I had a thought to communicate with the bar regarding the ethics of the pleadings and the communications in this case. I am not aware of any email correspondence between Detective Parvez and Will Hathaway, and I'm not in possession of. Obviously, if there's a report that Detective Parvez produces, and that report insinuates or includes those emails, those will be turned over. If the report reads as if there was email correspondence between Detective Parvez and Mr. Hathaway, I will ask Detective Parvez, please attach those emails in your report, and I will tender them. The court is well aware of the work product that I do and the ethics that I hold and how the fact that in this case, the allegations that this is some grand conspiracy is insane to me. It's truly insane. I've practiced in this court for a very long time, and I've never had an attorney accuse me of what has happened in his pleadings, and I take great offense to it. I will continue, and as I always do, to follow my constitutional obligations and the obligations in the Michigan court rules with respect to discovery. But I can't create discovery where no discovery exists.
I will respond to that by saying, number one, I did not do anything unethical in when I filed, and I agree that I should have no more conversation.
Counsel, let me just say, when I read your motion to compel discovery, and you were giving this background information, I'm not going to opine on whether or not it's ethical. I think you have made certain allegations against people that if I were to call you to task to say that that actually happened, I think you might be hard pressed to do so. The very fact that people with the same last name exist in an office doesn't mean that they had anything to do with it. In fact, typically, certainly as it would be between Patricia Reiser and John Reiser, I'll just say this, maybe what you're saying happened. Maybe. But the ethics of these individuals, if one's going to question them, then you better bring it. And not just try to float out that somebody did this or did that. Because, and I'll make it very clear, Miss Patricia Reiser has practiced in front of me for years. Known her for years. Her ethics are beyond reproach. The fact that I can tell you this and almost would bet my barker that if something came across her desk and it had to do with Scioto Township, and she knows that her husband is involved in Scioto Township, she'd have nothing to do with it. She would stop, would go someplace else, she would forget about it and never have a conversation. That's who she is, that's how she's practiced, that is everything about her. So when I'm reading this, counsel, I'm going to tell you I have serious doubts when it starts that way. But things can happen. And that's why I went to the file before we got here to figure out who had it. She didn't have it. Her name's not on it. And I don't think it's fair to make accusations about people, offices, how they operate, without being able to substantiate it. You tell a story that somehow or another somebody, after getting done reading this, here's what I've got to believe. I got to believe somehow in Scioto Township, there is somebody who went to the sheriff's department, made some complaint that the sheriff's department then, without any basis whatsoever, then put together a report that they submitted to the prosecutor's office based upon their investigation, and that it didn't have, that there was no basis there to do anything, that then it got into the prosecutor's office, and the prosecutor's office then said, well, we don't see anything here, but we're going to make this happen. Wouldn't happen here. And that's really how your document reads. Go ahead.
I was going to say, I apologize that it reads that way. You have to, if you would just see it from my perspective, I'm coming into this case. I don't know Miss Reiser. I don't know any of the players. All I know is seeing, and I see a woman who was part of essentially just an IT issue, and she ends up getting charged.
But counsel,
it makes no sense.
And maybe it doesn't make any sense. Maybe somebody made a bad decision in terms of their discretionary call. That's wholly different from saying you shouldn't have done this to that there is this intentional thing to happen to charge your client. I'm having a hard time believing that. So while you may have absolute faith and belief in your client, which you should, that doesn't mean we create a conspiracy as to why something happened. Somebody may have made a bad call. Okay.
I 100% agree. I only wanted to give you the players and what their roles were. That's all I was trying to do, where people were and why it seems fishy to me. This case seems fishy, Judge, and I want to know if there's any shenanigans. I want to know if there's shenanigans in emails or texts between witness Hathaway and the sheriff. That's what I want to know. And if they don't exist, then the prosecutor can just say they don't exist. I guess that's what he's saying. So I'll take his position as, unless he wants to change it, as being, I've checked with the sheriff and these exculpatory documents don't exist. If that's the case, fine, so be it. That's the record, and I will say nothing more. I appreciate the court's time today. And again, I do not mean to be disrespectful in any way.
So, because I'm not going to go through this again.
I don't want
Because, no, listen to me. You know, counsel, sometimes I want to just take attorneys back and just have them understand that in the privilege to practice law in this state, you need to be respectful of the process and the people. And you have to do it in a way that doesn't practice in a way that doesn't jeopardize your credibility. And I think people don't do that. And sometimes they don't do it with just the words they use. You know, Mr. Childers gives his response to your motion. I can tell you, I appreciate, I guess, Mr. Childers' discipline and how he responded, because I think if certain accusations had been made against me in my office, mine would have been a little bit more fiery than that. But that's just me. Do you have a copy of your reply?
I sure do. Would you like to? May I approach? Oh,
No, I've got a copy right here.
Oh, sorry.
I've got a copy right here. I want you to just follow along with me.
absolutely, sure.
In your reply, that it's their 11th hour filing of its response to your motion to compel. Really?
Yeah, it was filed last night or yesterday. I filed it weeks ago.
What's the need to say that? I'm going to know exactly when it's filed. What's the purpose behind that, counsel, really? To say that somehow they were deleterious in what they needed to do and just sort of threw that in? I mean, really, what's the purpose in that? Then go to the next
Can
paragraph.
I just answer your question?
Go
The
ahead,
purpose
if
is
there
to
is
explain
one.
Why this was short and done in the last minute.
Counsel, I know when everything comes in. So, and then you make the pejorative statement in the next paragraph, counsel. That the people shrug off their constitutional responsibility to locate and produce potential Brady material.
Yes.
Did they really do that?
Yes,
Then counsel, why do we get to the point today after this hearing? What have they shrugged off? List it to me. No. If you're gonna stick by that statement, list it to me.
Yes. It's constitutional duty, and I'll quote.
I know Brady upside down and backwards.
All right.
So you don't need to quote it to me.
But they shrugged it off because they said, I don't know about anything. They didn't check. They didn't look. They didn't become educated, as far as I know. Maybe they did. And I'd like to know that. If that happened, then they didn't shrug it off. But right now it looks like they did. Looks like they shrugged it off.
Even now?
Mr. Childers has still not said that he checked. He still has not said that he.
You have got to be kidding me, counsel. Even now.
Did he check for emails? Can I just ask him?
But even now, counsel. You sat down. Mr. Childers gave his response about what he would do. You sat down and you said, okay. I then read something that you wrote, and you're still maintaining that somehow or another they're not abiding by the Constitution in some way of jeopardizing your client's rights. I'm going to tell you, and I will assure you, counsel, in my court, your client's rights will be protected. And quite frankly, that is in regard to any attorney or whatever. Even if the attorney's not doing their job, I'm going to do my job and make sure her rights are protected. So but after we get done with all of that, you still are sitting here saying that he's shrugging off his constitutional obligation, counsel.
You asked, I thought your question was, why did I put it in there? Right now, if he's checking, then I'm not saying that. I do not still think that. Is that your question? I'm sorry. I misunderstood your question. I thought you were asking me why I wrote that. Sorry.
Yeah, well, I still am curious as to why you wrote it, because it's not true.
I disagree with you. I'm sorry.
Show me where it's true.
I just disagree.
No, show me where it's true. If you want to disagree with, you know what, counsel? The way I work, if you're going to say it, you're going to be called upon to put up or shut up. Show me where it's not true. Now.
The prosecutor did not educate himself as required by constitutional law, by going to the chairs, finding out if there were emails. I know there are emails. I know they exist. And for him to say they don't exist, it's not true. So there's emails. So I know that's not.
He's not in possession of any emails. He doesn't know that they, counsel, I've asked you what emails exist. Your emails or your knowledge of these emails supposedly come through basically 3 levels of hearsay as I count. And so the thing is, when I ask you, tell me what you want. When was it? What are they not giving you? You can't give me anything.
Your Honor, I know what I know, and I explained how I knew it, and that's all I know. Okay, so I'm asking though I was asking for a general.
Counsel, that's not the way I practice in my courtroom. If you come here, you better be ready to answer my questions and put forth what you're saying. I don't operate on speculation of something. If you're telling me that the people have something in their possession or have access to that may be exculpatory to your client, certainly, but even if it's inculpatory and they haven't given it to you, you need to lay that out to me on something other than speculation about whether or not something exists. That's the way I work.
How would I know? How would I know if it exists? If I don't have.
And you just can't make the accusation, counsel, that they're hiding something.
I'm just asking. I wasn't saying they're hiding anything. I'm asking for the information.
No,
Sorry if I-
your whole motion is an accusation, counsel.
I don't read it that way. I'm sorry. It is an accusation. No, it's an accusation
That they shrugged off their constitutional duties to produce certain evidence that they don't have, and you don't know if they have it or not. I mean,
I'm asking for it. I'm just trying to compel it. If you don't compel it, then I'm the one that.
what are we going to compel?
I would ask for an order saying, turn over any emails if they exist that are exculpatory. That's all. If they don't.
Counsel, that is about as useful as turn over every unicorn in your possession, because I don't know that they have either one. I mean, that's not a basis of a motion to compel, counsel. That's not how you practice. If you, and by the way, counsel, some of this you can FOIA, you can subpoena it. But you also have to do your job. And if they're not turning over something and you truly believe that they're not turning over something, then fine, come before the court. But be prepared to tell me what they haven't given you. Don't give me some conspiracy story. Don't give me all of these things. Don't say because something's politically charged one way or another that all of a sudden makes it something, because that makes no sense to me. You tell me what you want. If you think they're not giving you a direct answer to exactly what it is, then yeah, come here, I'll ask them. And they know I'm going to ask them. And then you can go from there. But you can't just throw everything up in the air saying they're not doing something when in fact that's not true. And here's the other part, counsel. The other part to this is, until Mr. Childers said so, because I didn't see it in any of the documents, this all starts from something you gave them. I mean, so you give them something, they fulfill their duty and obligation to try to follow up on it. And while they're in the midst of doing that, you do this. Crazy. That makes no sense to me. Why wouldn't you just wait? Find out if there's a report. If there's references to communication, then certainly one might be able to get those communications. But I'm not one that believes in a lot of conspiracies. But counsel, in as much as I want to believe, or you want to believe, that the prosecutor's office is running around trying to figure out how in the heck can I get at Miss Carey, why wouldn't I believe that you're giving them that document from the expert, having them go on what may be a fishing expedition, and then filing this motion is somehow and or another your attempt to try to make them look bad? Why wouldn't I think that that's the conspiracy you entered into?
If you knew my reputation, like you apparently know Miss Reiser, you would know that I wasn't trying to pull it.
Maybe then I operate on the presumption that people are acting in good faith until they show me something different. And that's why I don't go there to think that it's some kind of setup. I think you just messed this one up, counsel. I think you messed it up. And I think what you need to do is you need to make sure to wait for that. See what it says. The court will give you the time to analyze it, look it through. If there's a reference to some communication, then there's something there that says that it happened. But I don't have anything now. What day is this set for? The motion to compel discovery is denied. Mr. Childers, please prepare an order to that effect. Submit it to the court. As to the probable cause hearing, where do we need to go from here?
Hey everybody, I'm gonna jump in real quick. Let me get that thing off the screen. Okay, so that lawyer, the one who was goofing everything up, his name is Michael Bulata. He's a federal criminal defense attorney. He was also a former federal prosecutor for 23 years. So for 23 years, he was an assistant United States attorney in Detroit and Los Angeles. Imagine that. For 23 years, he was representing our country, going after people. That's amazing. That's amazing there. Look, a quick look up at him. This is a good one. And look, the news never tells you the retractions of stories. They just tell you the garbage stories. But it says federal prosecutor charged with assault denies slapping mother he calls his best friend. A high-profile federal prosecutor has landed in the defense zone. U.S. Attorney Michael Bulata, who prosecuted former Detroit Mayor Kwame Kilpatrick. It doesn't look like the same guy. I'm gonna back out of it, but it's got the same name of it, and everything's there. Somehow he got charged of slapping his 78-year-old mother. I'm gonna look back on it. Hold on a second. I'm gonna go over to the other screen, see if I recognize him on there.
Court does call the case of People versus Jillian goes someplace else. She would forget about it and never have.
Look, I'm just looking to see if I can find him on here. Yeah, it does kind of look like him. So do some research on the guy. Michael Bulata, Bulotta, charged with slapping his 78-year-old mom. I don't know if that's the truth. Who knows? It's just what the news is saying. Detroit Free Press. This is around Detroit. This is Ann Arbor, so it could be. Maybe, I don't know. All right, you guys have a great night. We're going to jump over to Court Addict with ATX Alley. You guys have a great night. We'll see you there.